Hello and welcome to Absolute Trust Talk. This is a Facebook Live version of our podcast. I'm Kirsten Howe and I'm your host here at Absolute Trust Counsel. So thank you for joining us today. I'm very happy to have you here. Today we are doing another in our series on what we call the elder care journey. And this episode, we're going to be focused on incapacity, and typically how that presents itself in my world is through cognitive impairment or dementia. We're going to focus just on a couple of the many, many issues around that word incapacity that our clients have to deal with. The first one being when does someone have sufficient cognitive impairment, sufficient dementia, that they are legally incapacitated so that somebody else can step in and start helping them, start taking care of things for them. So that's the first one. The second question that we see clients struggling with is when is someone's cognitive impairment sufficient that they legally are incapacitated and they are not able to do estate planning anymore. So we see both of those things pretty frequently in our practice because we work with so many families dealing with dementia. So I'm going to talk about both of those in just a minute. Before we get started, though, I'm just going to remind you of some of the housekeeping things that you already know if you've watched this before. First, I'm going to talk to you for maybe 15, 20 minutes. And at the end, I will answer your questions. So if you have a question, just go ahead and type it into the comment area on your Facebook feed, and I'll see it and I'll answer it when I get to the end. You can type it anytime. And then the second thing is we do record these. So there will be a video on our website. It takes us a couple of days to turn it into a video that's worth watching again, but it'll be up on our website, absolutetrustcounsel.com. So you can go there if you can't stay for the whole episode, or you want to, God forbid, watch it again, or you have a friend who should watch it. That's where you can find it. And we also turn it into an audio. It is, after all, a podcast. That takes a little bit longer, maybe about a week. So again, you can find the podcast on our website, absolutetrustcounsel.com, or you can find it wherever you normally listen to podcasts. Okay, so let's get started. Let's explore that first issue. When do we know that someone has sufficient cognitive impairment that another person legally can step in and start doing things for them? When are they legally incapacitated? And I am going to illustrate this by using a real life example with my real life clients. I'll change all the names, but I think it makes it easier for you to follow. So my client, Lucy, what happened to her is her mom, had been declining over the years, and she knew that. But one day she was over at her mom's house and she saw on the kitchen counter one of those PG&E power shutoff notices. Hopefully you've never seen one of those. You've only heard people talk about them. But that meant she hadn't paid her bill for a long time, and PG&E was telling her, you either pay it real soon or we're shutting off your power. So, that was kind of a wake-up call for Lucy. She immediately, of course, went and paid the bill, so that solved that little immediate problem. But she knew she had a bigger problem, which was, what else is going wrong here? And how can I get my arms around this whole situation and start helping, making sure that nothing else is slipping through the cracks? Fortunately for Lucy, her mom had an estate plan. Her mom was not my client. She had another attorney who wrote an estate plan for her. So there was a power of attorney, and in the power of attorney, Lucy's mom named Lucy to be her agent. So that was great. Lucy grabbed that power of attorney, and the first thing she did with it is she went to her mom's bank, thinking, I should start being able to write checks for my mom so I can pay all of her bills, and so they don't have to pay them out of Lucy's money, of course. But the bank wouldn't accept the power of attorney, and that's where I got involved. So she called me and said, what's going on? I have this power of attorney. Why won't the bank accept it? So she emailed it to me and I read it, and I had to tell her, the bank is right. You do have a power of attorney, but you don't have legal authority yet. So let's talk about that. So, most of you probably are aware that there are different kinds of powers of attorney. And one kind is what we call immediate. And that means that as soon as you sign it, the person you name in there has legal authority to act for you. Another kind of power of attorney is called springing, and that means the person you name in the power of attorney does not have legal authority until some future event occurs, and that future event is usually until I become incapacitated. So that's the kind of power of attorney Lucy's mom had. In other words, it said, when I'm incapacitated, Lucy has legal authority to act for me. Okay, so what does that mean? I said this episode is about what does that word mean? What is the legal significance of that word? When you have a document that has incapacity as a triggering event, you have to read the document to figure out what do we mean by incapacity? How do we know? And so in Lucy's mom's document, it said, if two doctors in writing state that I can no longer manage things for myself, that's when Lucy's authority arises. Two doctors. So that's a very common way for durable powers of attorney and trusts also. That's very common terminology, that formula of two doctors in writing. So once we figured that out, Lucy knew what she had to do, and fortunately, she was able to do that. She got her mom to go with her to two doctors, and she got the two doctors to make that written statement, and then she went back to the bank, and everything was fine. And it was a process. She got through it, but that's fine. So there's a few things that I want you to take away from that story, and the first one is Lucy's mom had a written estate plan. That was critical. If she had not had that, there wouldn't be any way that the bank was going to deal with Lucy. There wouldn't be any way the bank was going to turn Lucy's mom's checking account over to Lucy. They don't know who Lucy is. They don't know that she's got good intentions. Lucy would have had to go to court and do a conservatorship. So that's lesson number one. Lesson number two is, I said, if the document requires incapacity, we have to read the document to see what that means. Your document can say whatever you want it to say. It doesn't have to say two doctors. That's a convention. A lot of documents say that, but your document could be customized, and oftentimes we do customize the documents for our clients. So, for example, it could say, if two of my three children in writing say that I can't manage for myself, then I'm legally incapacitated, and somebody can step in and start doing things for me. The last thing I want to say is that without the document, you've got to go to court. So I'm just reminding you. And the two doctor thing, it's great, but sometimes it's burdensome. Sometimes it's difficult. And Lucy was fortunate. Her mom was willing to cooperate. Sometimes people with dementia aren't willing to cooperate. So just think about that. It can say whatever you want it to say. Okay, now let's go on to my second issue that we do see clients struggling with quite a bit. And that is that question of, when does a client lack capacity such that they legally can't do things anymore? And by things, in my practice, I'm talking about estate planning. So the example I'm going to give you here is that my client, Jim. So Jim married to his wife, Nancy, for 34 years, I think. And Nancy suffered a very massive stroke. She'd been to the hospital. She'd been in rehab. She was now in a skilled nursing facility. And the doctors were saying, she's had the physical therapy. She's really just not going to improve. She needs to stay in this facility or go home and have 24/7 medical care at home. Well, that's not financially feasible. So Nancy was in a nursing home, but still Jim was paying pretty close to $20,000 a month for her to be in that nursing home. And, he was happy to do it, but at the same time, he was very worried that he was going to run out of money and he wouldn't have any money to live off of himself. So he came to me because we help people in that situation. We help them qualify for Medi-Cal and still protect some of their assets so that the other spouse has money to live off of. So unfortunately, in Jim's case, they didn't have an estate plan already. So this is a very common scenario. The first thing we have to do is get a power of attorney from Nancy that gives Jim the legal authority to do the estate planning that he needs to do. A lot of people think that, we're married, my spouse can do those things for me. No, that's not the law. Even though you're married, you still have to grant your spouse legal authority to do estate planning for you, to do any kind of planning, to do any kind of asset moving. They can't do it without written legal authority. Okay, so what I did, this is very common, we do this a lot. I went to Nancy's nursing home and I met with her. I had to explain to her what it was we were doing, that we needed a power of attorney and what that meant and what that would enable Jim to do, and all the possible consequences and the negative consequences. And because I had to make sure that Nancy had the legal capacity to do that power of attorney. And what do I mean by that? That means I had to be sure that she was, number one, able to communicate with me, and number two, that she understood what it was she was doing. She understood the risks involved. She understood the consequences. She understood exactly what it was she was allowing Jim to do by executing that power of attorney. And although she was profoundly disabled because of the stroke, it hadn't affected her cognitive ability. She had a hard time talking, but she was able to communicate, and it was clear to me that she knew what she was doing and that she wanted to do it. So she satisfied me that she actually did have legal capacity, even though she didn't appear to. If you just walked into her room, she looked very, very disabled. On the flip side, though, a lot of times our clients with dementia, by the time we get there, it can be too late. They actually might be able to communicate, their mouths work, they can say words, but they don't understand what it is that we're trying to do when we're trying to get them to do estate planning. And so when we encounter that kind of situation, we can't do it. And again, what has to happen if we're trying to do something that the client doesn't have the legal capacity to do, it means that the family is going to have to go to court. And that's a conservatorship, which is not anybody's choice. It's a very difficult, prolonged process, and therefore very expensive. It involves a number of attorneys, and you don't want to have your family go through that if there's any way to avoid it. So fortunately for Jim and Nancy, we were able to get that power of attorney in place so that Jim was able to do the planning that needed to be done in order to preserve the couple's assets, so that Jim had something to live off of while Nancy was in the nursing home. And her care was still provided by Medi-Cal. So that was a really good result for them. Okay, I said that when we finished that, I would take your questions. So I'm going to now skim through here and see questions. Okay, here we go. What happens if an elderly parent makes changes to their estate plan at a time when they maybe did not have legal capacity? Okay, so this is a sad situation. All right, so I'm a lawyer, so I'm going to say it depends. Depends on the circumstances. If the elderly parent just wakes up one day and says, I think I want to make a change to my estate plan. They call their lawyer and they get it done. And then it later turns out that maybe they didn't have legal capacity to do that. If there's somebody who is adversely affected by that change, somebody who's harmed by that change, for example, the parent decides to disinherit one of the kids, that kid is harmed by that change, the child might raise an objection after the parent dies there, and that would be a court petition in the probate court. And this is sadly a very common scenario, if in addition to the parent makes the change, there's some other party involved. For example, the parent is living with one of the children and that child calls the attorney or makes the arrangement, drives mom to the attorney's appointment, sits in the attorney's office, and mom makes a change in favor of that child who's clearly actively involved in mom's life. What might end up happening is not only a fight over the change, but possibly an elder abuse allegation against the son. So that's why we've got to be so careful about making changes that might be what we call asymmetrical, where one child gets something that the others don't get. We have to be very careful about that because it could lead to litigation, and that's never good for a family. Okay, what do we do if we have a power of attorney and we also have the 2 doctor letters, but the bank we are dealing with still won't accept it? Okay, unfortunately, that happens sometimes. The banks they have to accept a legally valid power of attorney. That's the law, but they are very careful. And you can understand that to a degree. There's a lot of elder abuse out there in the world. There's a lot of fraud. So banks are being very protective. They're being very careful. So what I would say is if you have a bank that won't take your power of attorney, do what my client who I was talking about earlier, Lucy, did, call your attorney. A lot of times when you're dealing with a bank or a financial institution, you're dealing with someone who's on the customer service level. This is not the legal department. They're just telling you what they think they've been trained to tell you in this circumstance, but they don't really know necessarily what it is they're saying or what they're doing or why. So a lot of times by getting your own attorney involved, they can talk to someone in the legal department at the bank and they can work it out. They can figure out what the problem is and get that power of attorney accepted. The other thing I want to say about that question, because this is important, I think this would help a lot of people to know this, that most financial institutions have their own form of power of attorney. So you should do estate planning with your own lawyer, and your own lawyer is going to write you a power of attorney. But the very best thing you can do is, in addition to that, go to your bank and ask them for their power of attorney form and fill that one out also. So that way, when it's time for your kids to step in and try to help you, the bank can't possibly say, oh no, we are not going to accept this power of attorney. It's their power of attorney. They have to accept it. So that's a really great little bit of advice. And I encourage all of you to go out and do that tomorrow. Just take care of it. Okay, I think that's enough about that. Okay, if you have a written evaluation from a doctor that says the person does have the mental capacity to do estate planning, is that enough? So that's kind of the opposite of what I was saying. We don't have a doctor's statement saying she doesn't have capacity. We have a doctor's statement saying she does have capacity. Go ahead and do estate planning. Unfortunately, that's maybe enough, maybe not enough. It's what we have. The issue of capacity sounds like a medical thing. what is the level of cognitive impairment. But in this context, when we're trying to figure out, can we do estate planning or not, it's a legal question. So doctors can't rule on legal questions. The only people who can rule on legal questions are courts, judges, and juries. The doctor's written evaluation, the doctor's statement is really good evidence that mom, yes, has capacity. And so if we had a doctor's statement saying, yeah, she has the capacity, then we would be willing to do that estate planning with mom. It doesn't mean it can never be challenged, because it can be challenged. Only a judge can say, no, she had capacity. So it could be challenged after the fact, but it's very good evidence, and it makes it challenging for anyone to come back after the fact and say, hey, I don't think mom had legal capacity. So it's a good approach, and we often do that when we're not sure. We can't be certain that mom has legal capacity. We'll ask a doctor to evaluate her. Okay. I think that's the last of the questions. Let me just scroll down a little bit further. Yeah. All right. So again, thank you for joining me. This episode will be available as a video in a couple of days and as a podcast in a few more days. Go to absolutetrustcounsel.com. We have lots of other things there, ebooks, blog posts, other podcast episodes. We have a lot of videos. There's lots of educational stuff there for you. So go check it out. And if you need our help, we're here to help you. It's really easy. We have a little calendaring device on our website. You can just click on there and get yourself an appointment, and we'll get started. We're here to help. We're happy to help. We're honored to help. And once again, thank you for joining me, and I look forward to connecting with you next time.